Hello, good evening, ladies and gentlemen. Welcome back to the SAPI IP Business Talk. Today we are back in Europe. I'm very happy that Maria is with us. She is IP expert. She will explain what she's doing right now, and I'm happy that you are here. So please, all to the audience, this is a live show, and that means we invite you to make your comments, to ask questions to Maria and me in the LinkedIn chat, and I will pick that up and ask that. And in addition, when there is anything else, just let us know via the LinkedIn chat. And I'm happy that we have two accredited guests here also in the LinkedIn chat. Vincent Coteau, he's an MEPLM graduate, and happy that he can integrate here the industry perspective in our discussion. And Bastian Best, he is university lecturer for software patents at the IP Business Academy in different of our programs. And he will also join the chat and give comments and ask questions and give answers to the questions. So now to Maria. So thank you very much to be here. So when we made that appointment that we would like to invite you, it was about a very fascinating blog post which you wrote as an author on our blog, and then we said, okay, we would like to talk about that with you. So IP protection for mobile apps. And in the meanwhile, it turns out that you are an MEPLM participant. So I will see you in the classroom on Monday. And so that's a nice coincidence. And so first of all, welcome to our show. And would you like to explain us a little bit what is your background, what is your profession, and how did you came into that field of IP?
Thanks for having me, first of all, Alex. I'm very glad to be here. When we had this preparatory talk with you a moment ago, then you said that no little girl wakes up deciding to become an IP lawyer. Well, in fact, I was that little girl that woke up and wanted to be an IP lawyer. Well, I was not maybe so little girl anymore. I was around the age of 17. And back then, still on Lyceum, I had to pick a topic for my end work. And I came about, while browsing some journals, I came about the topic of know-how. And I got fascinated. And actually, that's where my love for IP started. I started exploring the topic. I wrote my end work in Lyceum on that subject. And afterwards, I also, coincidentally, I used the same topic as my very first speech at the AIPPI, the Association for International Intellectual Property Protection. In 2005, I was also speaking about the know-how protection. That's where it started. I started in Latvia. I'm actually from Latvia. So my career started in 2004 in Latvia. In 2008, I passed my qualifying examination and became Latvian patent and trademark attorney. Then I decided to change my life. In 2009, I came to Belgium to do an MBA. And afterwards, my career got a little bit of a management twist to it because I was also doing more the management consulting part of the story. Before I decided that no, my love still remains with the pure legal and the pure IP part. So I joined. I first went into the IP consulting, and then I joined last year Starks, which is a niche boutique firm specialized in intellectual property and international trade. So this is a bit the story of my life. And currently I'm doing, indeed, as you just said, I'm doing the master in intellectual property law and management with SAPI. This is basically to bring my legal degree, because I have a legal degree and I have the MBA degree, to have a little bit of a bridge between them, which I see in MIPLM.
Okay, wonderful, fascinating. Yeah. So, but to a little, to a certain extent, it is that there is some topic which is fascinating, and then people see how big that field is, how diverse that field is, and
Exactly.
yeah, and that it's so complex. So that so Dieter Stauder, my predecessor at SAP, he told me and said, Alex, this is the fascination of that field, that it is so interesting for intelligent people. Unfortunately, all these intelligent people make the things even more complex.
That's true.
Okay, so we want to talk today about IP protection for mobile apps. And I mean, in 2007, I guess, the iPhone was introduced to the market. In the meantime, we have, I, I would say, more or less a billion of iPhones were sold. And I think the figure I have is that in 2017 were 730 million iPhones in the world. And so I would say in the meantime, we reach a billion. And and with these smartphones, especially with the iPhone, the whole app thing started, and we learned that smartphones are configurable, so they change, so they have an operating system, and we can load apps on it. So that was quite strange for many people when you come from BlackBerry or from a typical mobile phone. They were like a pocket calculator, so you get it, and some software is in it, and that's it. And so we learned that, and in addition, over the years, not just apps came up, also very traditional companies started to make their apps. So, for example, I have I have a blog post on Humor. So they make these caravans, and they have now an app for managing a caravan, and also for organizing travels. So everybody has now an app. Even my car has an app, and
Well, frequently customers expect now that if
yeah,
there's a company, an app. If
exactly,
there's a product,
exactly.
there's an app.
And so with exactly, the customers expect that you take care. So at the end, when I have a product which has a certain value, I expect that I get an icon on my smartphone, right? So what would you say? So first of all, what are the opportunities here for companies to do that? I mean, very traditional companies for very, let's say, physical products like a car, start to writing apps and adding functionalities on apps. And the second part of that question is, what would you say? How do they have to adapt their IP strategy to the fact that they are now an icon in the App Store?
Well, to begin with, if we're talking about adapting a strategy, then I think that the most important question is, and what is the strategy? So you have absolutely different possibilities there, and a lot of possibilities. You have companies for whom that little icon is the product, which is the money generating vehicle. You have companies for whom it's more like the fancy business card. For some others, it's an additional functionality that they can offer to their customers. Like the example that you were using yourself, the Sonos in Spotify. It's a completely different model. Right? They go completely differently on that 5-layer model. It's the Sonos is selling the loudspeakers. Their product is a loudspeaker, and the app is an add-on, basically an additional functionality, an additional value, but it's an add-on. In case of Spotify, the app is the product. So this is about the defining, first of all, where you are, where you stand, and what do you want to achieve with that app. Why do you need an app in the first place? Like the app that I use just now, I have that sous vide stick, the circulation cooker, the thing that you put in water, and then it makes it makes it tasty. Whatever you're trying to make. Well, you can operate it just by pressing the button on the device, no problem. But I can also operate it with the app, and then it's just easier. However, the app is not something that they sell additional. It's just something that you get the access to when you have that particular sous vide stick. So first of all, that the company has to decide if they're thinking about whether we need an app, do we need an app, what kind of an app is, okay, why? What do you want to achieve? And what is your business model that you're gonna use in respect of that app? And accordingly, you would also adjust your IP strategy to it.
Yeah, I mean, what I learned, for example, from the Thermomix case, is that companies come from a very traditional business model, transaction orientated, like Sonos. So they sell a physical product, but then they learn a little bit like with your sous vide cooker, but even more here, they learn that the trick is not just giving the customers the physical product, because then the customers are gone away. So they go out of the shop, they go into their homes, and you have no further connection. And you cannot call them every day and asking, is everything okay? Do you want to something more, or do you want to learn something? So people would be annoyed about that. And so you need a tool to create a relationship, basically.
Yeah, to create the whole infrastructure around your product, and this also solidifies your relationship with customer. It enhances the brand loyalty. It enhances the possibility for interaction and for the upselling afterwards as well. So you have that relationship and you nurture it through the app as well.
Yeah, I mean the Thermomix guys were very nervous, because they said we are so Vorwerk is a very old traditional brand, and like Volvo or BMW. So I mean that are old brands, and now they tell us we are digital, and we are an app. We want to be in your daily life. We want to communicate with you, and this is quite a little bit, let's say, tricky to shift the let's say brand reputation, the brand recognition from a physical traditional from a physical product with a traditional business model to a relationship orientated business model. So because we had the discussion there, it's nearly 10 years ago, we had the discussion, can we update this app frequently? Because could people have the connotation that when we update the app, we made something wrong, we made a mistake with the old version? So like you would do it when you say the car has to come back to the garage because there has to be something adapted. So this is correlated with a mistake, with a failure. But the logic of apps is that they become better and better. So simply from a brand perspective, that's a big issue to go into that digital realm.
Yeah, it's also a lot about the communication. Like you said, people perceive that it might be that something might be wrong, but you also can, it depends on how you frame it, because if you frame it right, if the company has the right communication about it, then this can be perceived as, look, we are actually invented something new and we want to immediately share it with you. So we want to make it better for you. We are here for you. We are giving it to you. So it's also about the message framing.
I mean, what an app opens, the logic of an app is that it opens this digital realm, and you are not alone anymore. So you are a part of a digital world, of a business ecosystem. And the interesting thing is that patents, for example, have then a completely different role. So classically, we see them as an exclusivity tool, in terms of we want to exclude others from our solution. But when we are a part of an ecosystem, like with the recipes from Thermomix, we want to have exchange. So our patents have to bridge the way to others. I mean, that's quite a challenge for a company to change their strategic thoughts about, for example, here patents.
Yeah, yeah. Well, there's actually, when we talk about IP, then there's always, basically in every discussion, there's two main questions. There's the questions about the whether you infringe or violate the rights of the others, and the second question is what rights does it make sense and is possible for you to protect. So the two sides, one the more the risk management side, the other is the more your strategic part. Your actually not less strategic, more tactical, I would say.
Yeah. I mean, another aspect when we switch to the customer perspective. So for the customer, I would say they perceive an app just as a little piece of software. It's downloadable. It's an icon basically, and then I can listening to music, or I have a certain payment service, a route planner, whatever. But apps have obviously also other characteristics. For example, you can collect data. You know what your customers are doing. You can communicate with them. So is that also are there also IP issues with that? Let's say enhanced functionality of apps.
Well, there's a number of IP, let's call them issues. Yeah. To begin with, you have the graphic user interface and all the elements of that graphic user interface, which can and frequently are protected by at least the design rights. They also fall under the copyright, but you also if you want to, you can protect your icon, or you can protect parts of the look of the app. You can protect as a design. Also, certain animated graphic you can also protect as a design inside that app. You have the copyright issues, because frequently you use certain elements of copyright, and perhaps even elements of copyright belonging to someone else, like images or music, or some chimes, or even if we're talking about the icons, for example, if you use the standard, you want to communicate that you have to press and send an email, for example. Yeah, if you use just a classic envelope, you're not violating anything, but you could be using some sort of a nice stylish envelope designed by a graphic designer in the other app, and then that's a direct violation if you actually saw it and you used it because you saw it. If there's an element of copying, because for copyright violations you have to have element of copying. So of course you have patents for certain elements. I guess one of our guests today, Bastian, knows best about that, because that idea that software is not protected by patents is a bit of a stretch, because there's a lot of elements that can in fact be protected. If there's a technicality to that solution, then it's perfectly possible. So yeah, there's a lot of questions that can and should be asked related to IP in respect of many elements of the app infrastructure. And like you mentioned, also the data protection. We in Europe have the GDPR, and if the single user from is qualified as an EU user, then the GDPR applies, and you have to take it into account. And from the moment that you actually start developing the app, because it's the principle of the protection by design, and you have to have it from the very beginning. You have to start with that when you're developing the app. So you have to make sure. Yeah.
Mm-hmm. Yeah, but what you say is that we have a very complex IP issue here. By bringing that app into the market, making sure that it stays exclusive, that it is not anyhow copied in a wrong way, let's say, in a not willing way. In addition, we have infringement issues, that we might use other technologies, other copyrights, trademarks, whatever. And I mean, we have that in all the gaming fields, where also in
Well,
app
gave a
environment.
clash of clans, huh? You
Yeah,
have
so
the patent litigation there.
something pops up
Yeah.
from the real world. It's branded, and you cannot use it just because it's a game. And it is the same thing, of course, in the app environment. So what my question is, what is your experience when it comes to when you work with companies? Are they aware about that enormous complexity, this IP issues around an app? Because they assume, so my experience is the typical reaction, yeah, we launch an app is software cannot be patented, that's it. I mean, that's the whole story. Where is the issue? Yeah.
Do I have the issues? Yes, I faced quite some issues with our clients that related to different aspects of mobile apps. And just recently we had a case where it was rather not about the patents, it was about the app development as such, because when we're talking about such a complex thing, then obviously there's many actors involved in actually creating it, in bringing it to the market. And you have also huge differences there with who developed the app. If the app is developed in-house, if the app is outsourced, so who is a developer? And because the one who develops, by definition, has the copyright, and the IP questions have to be tackled very carefully. You have to address them very good in the agreement. And the issue that our client had was that the agreement was just written that everything belongs to him, and that's where it ended. But there's so many nuances, there's so many details that had to be explicitly taken care of, because it's not enough to just say that the IP belongs. You have to, if the app developer, the outside app developer, is developing the app for you, you have to have an assignment, and in many countries written assignment of that copyright into the app, and not just have a small note in the agreement. So
but my question, excuse me, Maria, my question was a little bit different. So that there are issues, and sooner or later they arise. I mean, that's clear. That's sure. That's for sure. So they can. So with that, millions of apps, we can hire also millions of lawyers to solve all the problems. What my question was, is there a certain awareness, so to speak, before the project starts, that there is a lot to make sure, so there's a lot to regulate, a lot to organize, to make sure, to claim certain provisions which are needed, or is it typically that companies run into that field without an anyhow awareness about IP and how complex the IP issue is here?
Sadly, it's the second. So sadly, they do run into, okay, let's launch the thing and let's figure all the things out later. And then later you will have to have the lawyers to solve the problems. And that awareness is indeed something that's very much lacking. Awareness in respect of everything, in respect of what's possible, in respect of what can go wrong, in respect of whose rights and actually which rights and whose rights you can infringe. Because somehow there's also here I'm thinking about trademarks, for example. You are not obliged to register a trademark. You can do without. However, it's not only about claiming, exclusifying that trademark for yourself, not only about claiming that trademark for yourself, but it's also about making sure that you don't violate others' trademarks. And that's somehow doesn't click, that risk management element doesn't click very frequently.
Yeah, I mean, exactly. There's exactly that mechanism that quite often what you're doing is you use, for example, typical symbols, or you use a typical human-machine interface logic, and because simply customers expect that, And later on, it turns out that the way how you created this solution is simply infringing because you did it in a way. Excuse me, I have a technical issue right now here. Oops, I lost you. So now you're here.
Okay, good.
And later on, it turns out that they used them. I mean, we had this Sonos Google case, and it is not that Google is just stupid and that they didn't know that they infringed the patents from Sonos. I mean, what happened is that Sonos introduced a certain interaction pattern, and that the customers expect that. And then when it's the same thing with, as you said, with this envelope, with symbols, with ways how to manipulate apps. Also, simply the logo which you're using, the icon, that there's a lot of potential, especially because there are the expectations of the customers, how an app is working and how an app looks like, that you infringe third-party rights. And my experience is that people are, as business people, are quite often not anyhow aware that these are IP issues which are seriously, so in terms of the ultimate consequences that you go out of the iTunes store because of IP infringement. And
yeah, well, you can fly out of the App Store because their policies basically first kick you out and then figure out if the violation happened, yes or no, because they're very stringent on potential IP violations. So that's indeed the case.
What would you say? What can we do about that? I mean, that's an issue, and one thing is that we complain that it happens. Another thing is making, for example, such events like today, but in really on the ground floor. So what is your way to explain that to business people? And when are you involved? Is it just when the shit hits the fan, or is it a little bit before?
Well, frequently it's the former. Well, it's actually most of the times it's indeed already a bit too late that the business people start coming to a lawyer for a consultation. And at that moment, it's already the time to actually do quite a lot. And that's actually the reason why it becomes much more costly, because if you start with the advice and if you then act on the advice, it might be for you even financially more beneficial to just think through those things in advance. Because when you were talking, another example came to my mind about the open source code, because very frequently you use the open source code, but open source doesn't mean that it's IP free. It doesn't mean that it doesn't come with a license. And sometimes you have those so-called copyleft licenses, when you actually have to then use the same licensing terms for your final product. That will kill your business model if you intended to commercialize it, and then you use the open source code, and you can either you can just say bye-bye to your business model, or you will run into the litigation risk. So there's a lot of those issues that can be just at least talked through in advance. And if they are, then there's a possibility to avoid them, and not to come to a lawyer when, as you said, the shit hits the fan.
Exactly. I mean, that's exactly the point that digitalization. So the fascinating thing is that people think digitalization is more or less software, and software comes more or less without IP, and they have this huge misunderstanding. Software cannot be patented, and so and open source has nothing to do with IP, and so on. So we are in an IP-free space. So de facto, the opposite is the case, that digitalization comes as a more or less pure IP issue, because it's not the technology, it's not the the hardware. I mean, hardware is ubiquitous. It's the question how we use this intangible in terms of software, and once we have that, then we have to understand what is on top, with the way how we act with IP. So I'm a little bit, yeah. So we make with the EPO in May the next a big seminar for the medtech industry, but it's about software. It's about software in medtech industry, and that they learn what's about IP and not just patents. I mean, as you said, the full bunch of issues, especially with open source licenses. Okay, so let us look to the question of avoiding third-party infringement, so so-called FTO. So what is your experience about that? Is there a certain awareness in terms of that the development process has to be adapted to that, or is it the same, like we don't care because we think nothing can be protected here, and so we think nobody can have any rights?
There's frequently another shade to it, that companies believe that if they haven't seen the commercialization, then there's no patents. And the fact that they looked around at their competitors and they don't see that something like that exists, they think that there's no need to have the FTO and to actually explore if there are those rights. And this is something that I've seen over and over again as well, that it's a belief that's ingrained.
Yeah, it's a little bit like this thinking: when I have a patent, I am allowed to do what I have patented. It's a little bit like that. Yeah, so that are two different issues.
That's two different issues.
Yeah, it's obviously not clear, and so it's a little bit like this pharmaceutical case. So I see that so often that companies which have nothing to do with pharmaceuticals, but they behave like them. Yeah, so they say, okay, I have an R&D. So in terms of patents, I have an R&D result and I patent it because every R&D result is it worth to be patented, and when I have the patent, I am allowed to do it. I mean, that's to a certain extent correct in pharmaceutical, but this is totally misleading for everybody else. And the world is, as we said, for apps, extremely more complex. And typically companies are not prepared about that. So when I come from, so again, Thermomix, okay, it's a kitchen machine with an electrical engine. So how many patents do we have in the world every year for electrical engines? So it's not that much. Okay, so that's for civilians, so you can check that, and it's easy to get an overview about that. But when you switch and say, okay, we make now an app, or we make a recipe and we download that recipes to our machine, you are in a new world with that decision. I mean, it's a PowerPoint slide. It's not more. It's one PowerPoint slide. We want to go into that route, but you change your IP realm completely, and they have no structures for that in the company, no organization. Nobody knows anything about that. I mean, that's crazy, because it happens in so many companies. So, which means you should have to work day and night, right? Because it is ubiquitous, that this kind of problems.
Yeah. No, it's what I do see, unfortunately, with many companies is that IP in general is some sort of a black box for them. They perceive it as something that, we know it exists somewhere, but it's not for us, or we kind of know something, we maybe even registered a trademark, or we are aware that we might. But there's a misconception that IP can actually also help the business, so that it can help the business build those relationships. In case if you are able to license something, you are able to get the income. So there's so many things that you can do with IP that are gonna benefit your business, and that can prevent the problems, that can benefit you. And yeah, in the end, it's all about making it work and making it work in the best possible way.
Yeah, and what you say is, I mean, that's exactly my experience. That I'm always saying, thinking about an IP strategy does not mean that you have to think one thought in addition compared to thinking about your business strategy.
Yes,
So
it's absolutely intertwined. It cannot be without each other.
yeah, but that means we have to talk about your business model, and we have to talk about the way how you want to compete with your competitors. And in so far, we need to formalize that to a certain extent, because then we can work with IP. And I saw that really often when I tried to talk about an IP strategy, and when I start and say, okay, there is nothing like an IP strategy. What we have is your competitive strategy, your business strategy, and then we ask, how can IP help you with that? Okay, so then they stare at me and say, what do you mean with helping? Yeah. So, as you said, the connotation is IP is a bad thing. It is costly. It's only for the big boys. It has nothing to do with me, and I hope it is going away. Yeah, so a little bit like tax. Yeah, so I hope it goes away, but it doesn't.
Exactly. But that's where we started with. It's defining the IP strategy starts as defining your strategy and which market you're in. What's your product? What's your business model? What are you doing there, and how are you getting money? And then only then you can decide what needs to be exclusified, what doesn't need to be exclusified, where you have to think about potential mitigation strategies or something. But it all starts with actually defining where you are and where you're heading.
So let's come back a little bit to the development process of an app. I mean, that's, for many companies, this is maybe the first time that they develop really a software component, a pure software component. And so it's quite challenging. And typically, the traditional companies don't do that on their own. So they have agencies and they have service providers. And what is your experience here? What do you, let's say, recommend to a company which has not really experience in software development, especially not in external software development? So about what has to be done about NDAs, trade secrets, copyrights? What would you say?
To start with, crystal clear agreements. That's the starting point. Crystal clear agreements. I cannot repeat it. Yeah, it's essential to define the process, to define who owns the IP rights, to define how is it gonna be. For example, if we're talking about, let me step back. If we're talking about the actors around, you can have multiple agencies actually involved. You can have the agency for the writing of a code, for actually programming, and you can have an agency for doing the graphic design. You have to make sure that what they use is also not gonna run you into trouble. I mean, if they use what we already mentioned, the open source, if they use, for example, if it's a graphic design agency, which copyright material are they using, and what are the licenses, what are the warranties that they received, and can they pass them to you? You have to make sure that your subsequent relationship with the App Store is also figured out, because are you gonna then upload the app to the App Store? Are they going to have a relationship with the App Store? And what's going to happen in case, for example, you don't want to proceed with the same agency? So you need to make sure that there is also put in some mechanism for transfer of that knowledge and of your documents, your code. You have to make sure that there's a transfer, that there's an assignment of rights. There can be that situations, for example, if the agency is developing the code and they're using the some of the previous codes that they developed, so some of the other ones. You also have to foresee that there is that everything is figured out there, that there are licenses in place, that there's that your rights are not violated. In terms of NDAs, of course, for instance, when you just start the conversation with the agency, you selected the agency, at that moment you already have to sign the NDA from the moment that you start discussing. And NDAs and the NDA clauses have to be also like in your employment agreement. You have to foresee that there's clauses for non-disclosure of trade secrets of the company. You have to educate in terms of your own company. You have to make sure that you educate your employees, and not only that you have those provisions in contracts, but that they actually understand what they mean. And on top of that, it's very good to have the actual physical measures that you foresee. So that's in terms of inbound, let's say. Outbound as well. With the agencies, it's a pretty detailed agreement that has to be put in place. Also in terms of warranties, also in terms of, okay, what's going to happen if the App Store, for example, kills the app, removes it. Yeah, who's gonna you're gonna suffer financial financial issues because of that. And it kind of makes sense to foresee what are you gonna do and how are you gonna handle that relationship with
is it also a quality management issue when you are delisted?
That as well, yeah. That as well. That can be as well. Then also the questions of updates and new releases. So how this will be structured, how this will be approached. So there's actually a number of issues that have to be addressed, and another number of issues that can be addressed.
And especially negotiated, right?
Of course.
Especially negotiated. And because two things come into my mind. First, we're running out of time. No, what I want to say is, and even more agencies can be involved. So, for example, a UX agency and others who make certain aspects of it. So you have a multiplayer game here. And it is really critical to discuss who is doing what. And then I would say what many people forget when they think in a traditional industrial mindset in terms of start of production. So I develop something, and then comes the start of production point, and that means from now on we don't change anything. So now we make the mass production. So software is the exact opposite. Okay, it's never ready. It's never finished. It has a certain level, but it is a moving target over the time, and it's not such a rare case that you change also the partners over the time. So because you want to have more functionalities, you learn, you have other business opportunities, and then you change the partners. And I mean that is a tricky issue. As you said about the IP rights, when you want to work with others, or you switch the work from one to another.
Well, you also have the third party service providers, like the PayPal, for example, if you want to have payments there, or you have the integration with Google Maps if you want to have geolocation. So you have. Yeah, they're also partners. There has to be licenses in place. There has to be all those things have to be thought through and figured out, and preferably in advance.
So first of all, thank you very much. It was very interesting, and I hope also that the audience learned something about the issues. So we don't want to say everything is problematic and everything is a problem. We just say that you should think the project in advance through. And then it is much easier to negotiate and to regulate, to make provisions what you want. But that means you have to think what you want and how to want to run the business at the end, and not just starting a project and then waking up once morning and say, oh God, the whole thing went sour here. So,
exactly.
Okay, I want to say thank you to our guests, Vincent Couteau and Bastian Best. Take care. Thank you very much for taking your time this evening, Maria. Bye-bye to Belgium. Stay safe. We still have some trouble with Corona, and I'm looking forward to meet you in the classroom.
Well, see you soon.
See you soon.
Thank you very much, and I'll make sure that I afterwards come to the comments to see if.
Exactly. So thanks to the audience, and bye-bye for this evening.